After their conviction, the Menendez brothers could soon walk free, not just because they're now eligible for parole, but because a judge has ruled new evidence in the case, if true, could overturn the murder convictions against them. The LA County DA's office now has 30 days to respond. The brothers' attorney, Mark Geragos, he joined us now live on this new development. Good to see you. Congratulations on this new development. This is another big win for you. This is, quote, new evidence that we've talked about before, though. This all has to do with something that you filed in LA County more than 2 years ago.
It's exactly right. And by the way, congratulations to you and welcome back. The original thing that kind of got the ball rolling, so to speak, for the Menendez was the filing of the habeas petition. And as we were kind of litigating that with the DA's office, as you will remember better than anybody, at a certain point, the predecessor DA, George Gascon, moved for resentencing, and then we kind of placed the habeas on hold while we moved forward with the resentencing. We got them resentenced. They have a parole hearing that's scheduled for next month, but then we did pursue, as soon as we had the resentencing done, we went back to the habeas, and we're cautiously optimistic because lo and behold, that we just received the order over the weekend from Judge William Ryan saying that he was now telling the DA, formally, you must respond to the habeas corpus, otherwise I'm going to toss the convictions.
And this is based on the evidence, though, about the letter that Erik wrote to his cousin in 1988. I think it was 8 months before the murders of Jose and Kitty Menendez, which would prove that there was a detailed the sexual abuse that he suffered reportedly at the hands of his father. And then also abuse claims from the former musician of Menudo, who worked under Jose Menendez's record label.
Right, and the reason this is significant, you might remember, the current DA, not just Mr. Gascon, but the current DA has been forcefully, vigorously diminishing the idea that sexual abuse would mitigate murder to a manslaughter. And these two pieces of evidence, we've always argued, are compelling. I mean, the one where the letter, which was written to Andy Cano, Andy is now dead. At the trial, the DA's office back then was basically challenging his rendition that he knew about it in real time from Erik. This puts the lie to that challenge by the DA. Then you combine it with Roy Rosello's declaration, and wow, I mean, you've got now somebody else who says not only did this man, Lyle and Erik's father, rape them, but where did he do it? He did it in the house. That's where he felt safest, and that is a game changer.
Yeah.
So put both of those together, and I think we've evolved since the 90s, I think, and this order, I think, will put the DA, I keep hoping against hope that the DA will just say, okay, enough. It's been 35 years, given the manslaughter, or set aside the conviction and let him out.
I don't think LA County DA Nathan Hochman is going to do that. With that said, though, how soon will we know anything? I mean, he has 30 days, so I guess that answers the question. But where does that fall with the parole hearing that's set for August?
Both are very close. So you've got the DA is due prior to the parole hearing. Then we would be able to respond to that. I'm hopeful that we can potentially fast track it. I agree that given all of his pronouncements, that Mr. Hochman doesn't seem likely to acquiesce, but you know, who knows? Maybe he'll get a little conversion on the way to Damascus. If there was ever a case after 35 years of two people who were convicted in that second trial unfairly and now have evidence to demonstratively show that, and who should be released or have their convictions set aside, these are the two guys.